Rise. The justices of the Appellate Division, Supreme Court, First Department. Immediately, all persons having business with the Appellate Division. Draw near, with your attendance, and shall be heard. Please be seated.
Good afternoon, everyone. Welcome to the Appellate Division, First Department. We have some 4 hours of argument that have been requested this afternoon. So please bear that in mind as I call the calendar and ask only for the time that you absolutely need to make your most important arguments. Understand that we have the briefs, your briefs, we have the record. We're fully familiar with the facts of your case. So please keep that in mind as I call the calendar. People versus J.F.
The appellant requesting 8 and 2, Your Honor. And the respondent requests 8, Your Honor.
6 and 2 and 6. Gill versus Calfee.
Your Honor, appellant, New York Presbyterian Hospital, 4 and 1. Juan Gonzalez for the appellant, Dr. Petrillo, 4 and 1.
Ellen Fisher for appellant, Hospital, plus 3 and 2. And Sharon Appellate on behalf of the respondents.
Did you give me a time? I'm sorry. This is not a cross appeal, so it would just be 5 minutes. Okay, 4 and 1, 4 and 1, 3 and 2 and 5. Thank you. V.S. Children, submitted. Gap versus 44-45 Broadway Leasing.
Good afternoon, Your Honor. Stephen Mull for the 9 and 3. Norman Flint for the respondent, 10 and 2.
5 and 2 and 5. VIIMP Miami Hotel versus Highcroft.
Andreas Christie for appellant, Highcroft, 5 minutes requested.
Is there a respondent here? No. Do you wish to submit?
I would like to briefly,
So I'll give you 2 minutes and a submission. Okay. People versus Anthony Campbell. Submitted. Bullard versus Sheffer.
Catherine Hines for appellant, Jasmine Bullard, 8 and 2.
And the medical for respondent, first appellant, Peter Sheffer, 10.
6 and 2 and 6. People versus Michael Pittman.
Appellant requests 5 minutes on direct, 2 in rebuttal.
How many? 4 and 1 and 2. Winkler versus Hallmar International.
5 and 2. Almar respondent, 5. Plaintiff Winkler, 7. Respondent, City of New York, 2 minutes.
I'll give you 5, 2, 5, 5 and 2. Drone USA versus Antonellis.
Dennis Antonellis,
6, 2 and 6. People versus D'Angelo Coleman is submitted. Italian Elegant versus Feta, submitted. Chang versus Westside, 309, submitted. First case for argument is People versus JF.
Adam Merfar for Appellant JF. May it please the Court, Your Honors.
The stated foundational purpose of SORA is to assess the threat to public safety and the risk of reoffense.
So, counsel, I believe that you're asking for us to apply 168, and I could be wrong, so you'll correct me, 168A to E. And that part of the statute is one that is addressed to the original request at sentencing for SORA. And at that point, one can make an application to be considered a lesser, at the hearing, to be considered in a lesser category, or not to have SORA apply. I don't think that happened here. Is that correct? That specific request wasn't made here.
Your Honor, there was an application, I believe, at the bench, and Judge Obis at the trial court level made the determination that registration was appropriate for JF.
And was that challenged? Did anyone offer?
It was not challenged.
Okay, so then that wasn't appealed, that aspect.
It was not appealed, it was not challenged.
Okay, so right now, it would be 168O, I think 02, wouldn't it be?
Yes, Your
With
Honor.
regard to that, which applies to a level 2, where of course, with a level 2, you have to report for life until 30 years, and then you can make your request at that point.
Well, that's not what the statute says, Your Honor, respectfully.
Okay, tell me what it says then.
It says that any sex offender may apply for modification. And of the more than 35 sex offenses that were designated by SORA, each of which, if you're convicted, you must register. There is no...
Counsel, it says modification, though. How can it be a modification? You're requesting that he be removed completely. That's not a modification, that's an elimination. And there's nowhere in the statute, unlike for level 2, there is a place where they could eliminate the requirement. There's no equivalent provision for level 1.
But the legislature uniquely and exclusively carved out unlawful surveillance as the only crime in which the court has discretion to decide that registration is not appropriate for that defendant.
As my esteemed colleague just stated, that only comes into play at the initial disposition when you are first sentenced. There's nothing in the statute that even suggests or hints that you can make a later request to not have to register anymore.
Well, Your Honor, respectfully, that's not what the statute says. I understand there being some holdings that have suggested otherwise, but never in the context of a petition for modification under 16802 as it relates to someone who's convicted of unlawful surveillance, which the legislature uniquely carved out that discretion.
Is there any case that has permitted a modification from a level 1 to no level at all? Is there any case that has perceived the statute as you are articulating it here?
No, and there's also no case that says you cannot do what I've asked the court to do, or what the petitioner has asked. Again, I think
You just said there's no case. What about Wyatt and Ayala? Don't they exactly say that?
Your Honor, Wyatt was a level 2 out of the second department requesting to be a downward modification of level 1.
But
But it was in
just said
dicta,
there's
and it
no
was
case that says it.
completely irrelevant to anything with regard to the case. So, in terms of a controlling decision, I don't believe that there is one. I think this is a case of first impression, and that the statute specifically allows for a court to have the discretion when it comes to people charged with unlawful surveillance. For the statute to have any meaning, the word any sex offender must have meaning. Now, we know that the legislature went and amended the statute several times, but for some reason, they left in the term any sex offender. They didn't say, oh, only level 3 or level 2 offenders may apply for modification. They said any sex offender. For that phrase to have any meaning, the plain language, then there must be an ability to petition for modification. And if the court had the discretion at the time of sentencing, when it had a very small pool of information about the defendant, there is no rationale for saying, hey,
Except that the statute permits it at that point. There's nothing in the language of the statute that allows what you are suggesting, other than the word any.
well, there's also nothing that says you can. And if you look at what the language of 168A-E2, it says you make a motion to the trial court, which is what the petitioner did in this case. And there is no reason why
Now, 10 years later, the court is in a much better position to determine whether registration is harsh and inappropriate as it relates to JF now. He spent 10 years bettering himself.
Wouldn't the proper time to have made that motion to the trial court been at sentencing?
Well, Your Honor, in this case, he didn't dispute that it was an appropriate assessment by the court. By the nature of the circumstances, it was discretion that the court, and he said, okay. And he went and spent 10 years bettering himself. And the statute is also remedial. By allowing for modification, the statute by its nature is saying, we believe you can change. We want you to better yourself. We want you to rehabilitate yourself. So therefore, Your Honor, if the statute allows for modification, if it believes in the remedial nature of people that they can change, then isn't the court in a better position now, after all this time, to use its discretion that the legislature carved out specifically for those convicted of unlawful surveillance? Thank you.
Thank you.
May it please the court, Melantra Chandra for the people. There is no statutory authority for the relief defendant seeks here. What defendant essentially is asking for is relief from registration, and that is governed by subsection 1 of the statute and does not apply to level 1 offenders.
Is this unusual? Is it unusual that there is an option for a level 2 offender and yet no option for a level 1 offender who is usually convicted of a less serious offense, or if that's the way to put it, I don't know, but has fewer points
Sure, Your Honor.
and is in a lower category?
I do not think it's unusual, and that was the legislative intent. If you look at the way the legislature has modified and revised the statute, it was level 2 right now. They have to register for life, including with much more violent level 3 offenders, sexually violent, predicate violent. They are right now, when the legislator amended 168, also amended the time for registration and made a legislative determination that level 2 would move from 10 years to life, whereas level 1 would move from 10 years to 20 years. Now, for life registration, the legislator carved out an exception and the possibility of relief only after registering for 30 years. So at a minimum for level 2, 30 years is required, and the legislator made it abundantly clear by increasing the time for level 1 from 10 to 20, that 20 was an adequate time to take into consideration the public harm that would happen should there be reoffense, to protect the public, which is another one of SORA's purposes. So as your honors have already said, and I'm not going to belabor it, section 168A to E applies, which applies at the time of certification and sentencing of defendants who are convicted of second-degree unlawful surveillance, so it's not applicable, and neither are the other provisions for registration or modification. And the legislative history supports that plain language. So unless there are any further questions, we will rest on our brief and request that the order be affirmed. Thank you, Your Honors.
Thank you.
If the legislature intended that the sex offender registration be set in stone, they would not have put in the provision that it can be modified. The whole reason they have a modification aspect to the statute is so that people can better themselves, rehabilitate themselves, and the initial adjudication may not be appropriate at a later time. The petitioner's petition to fall under the plain language of the statute, which gives the court discretion, that allows any sex offender to apply for modification. It meets the spirit of the statute, which allows for the remedial nature, where people can change. And it also meets the foundational purpose of the statute. The purpose of the statute is to assess the risk of recidivism. And if a registrant is no longer at that risk, and a court has the discretion to find they're no longer at risk, that they shouldn't have to register, then that's what the court should find. We should not be stripping the lower court, of its power, discretionary power, when the legislature specifically carved out that discretion for this unique offense. It is the only one the legislature decided the court should have that discretion. Thank you.
Thank you. Thank you both. I'm going to call Gill versus Calfee last. I'm sorry not to have pointed that out to you at the beginning of the calendar. I'm going to call that at the end of the calendar. The next case for argument is the Gap versus 4445 Broadway Leasing.
May it please the court. I'm Stephen Mullo, and I represent the Gap in this case. I'm aware that 4 of the 5 members of this panel served on the 170 Broadway panel, but the sophisticated parties to this lease negotiated and agreed to a fundamentally different purpose in their contract. They agreed to the operation of a flagship.
So, counsel, I understand that your focus is on the fact that the contract speaks to flagship and has hours of 10 to midnight in this store. But I think here we not only in this division, in the first department, dealt with the case of the Gap, but we've also already, in a number of other cases, Valentino and Center for Special Care, found that frustration of purpose is not applicable, where the purpose of the lease, the contract, has not been completely thwarted. And that certainly is the case here. So aren't you just revisiting the same issue? I mean, does the fact that this is a flagship store pose another distinction that we overlooked with regard to frustration of purpose? I believe that those stores were closed from March to June and then were opened. 50% capacity, I believe, but opened. And thereafter never closed, just opened more and more to a greater extent.
So there's about 3 questions there, Justice
Okay, you
Frederick,
can pick the first one. Why
answer all of them.
aren't you revisiting cases that we've already decided?
The answer to that is no. None of the cases that you have reviewed have involved flagships. The purpose of the lease flagship, that word appears 8 times in this lease, and it's a term of art in the real estate industry. If you look at the amicus brief provided by the director of retail studies at Columbia Business School, Professor Cohn, he talks about how flagships are experiential. They are not, the sale of merchandise is secondary.
Was the experience, I think you say that you couldn't conduct the experiences anymore, but just the way the store was open at 50% capacity, couldn't the experience still have occurred in that, just in a lesser capacity?
No, because it's not just the opening or the 50% capacity, it's really looking at all of the things that were part of that at that time. Remember, flagship is an opportunity for the retailer to have an emotional connection with the customer. The purpose of the lease in 170, in 170 Broadway was to have a prototype store generally consistent with the majority of Gap stores. Same thing with Valentino, same thing with the Ponte Gaeta case that's in the federal court. None of them talked about flagship. And it's not just the 50% capacity, it's the masking, it's the social distancing, it's the...
But that was true for all stores.
I'm sorry?
That aspect was true for all stores.
It was, but not all of those stores contracted and paid an extraordinary amount of money to have a flagship. The rent at Times Square, this store, was 3 times the amount, almost, per square foot as what was being paid on Broadway, and that Broadway store is a pretty Tony address as well. So the difference is creating this space where people can have an experience. And as set forth very clearly in the brief of Professor Cohn, this is something that's a very real thing in the retail industry and in real estate. Now, when you look at the provisions in the other leases, as I say, that you've reviewed, none of them refer to flagship. And unfortunately, the 170 Broadway case, I went back and looked at the briefing of it, and it doesn't address a number of cases. It cites the Kelly case, which is a 2016 case from this court in which there was an issue about what the certificate of occupancy was. It said commercial. They contracted for it to be commercial, but in fact, the certificate of occupancy was residential, and this court said the lease was frustrated. But if you go back further, there's 100 years of precedent in the New York courts.
Even if you were ignoring, it's not only did we hold it in the Gap case, we also held it in Valentino, which I would argue is much more like a flagship type store, and that's an argument they made in that case also, and this court has clearly rejected that. So I'm not sure how you can possibly distinguish Valentino in addition to the Gap case in arguing that this should be decided any differently at this point. We have obviously made a determination in these COVID situations that it doesn't rise to the level of frustration or purpose.
We look to the terms of the lease, and may I answer your question, even though the lights out? And the terms in Valentino do not include flagship, and then the question is, what's the primary purpose? I just commend you to the cases cited at pages 18 to 24 of our brief, including Doherty, Kaiser, Kramer, and in addition to Kelly, and a number of other cases from World War II, from Prohibition. In the Kaiser case, the parties had contracted to have, occupying the space, a saloon.
Yeah, but you're talking about, I'm sorry, you're talking about the cases. We can continue this on rebuttal.
Okay.
How about?
Thank you.
May it please the court. I think we focus on the permitted use clause of the leases here with the Gap and the Old Navy stores at Times Square. And it's very, very similar to the use clause in the 170 Broadway case, where the Gap shall use and occupy the premises subject to the provisions of the lease for the sale of apparel and accessories and a tenant's option, such other ancillary uses as are consistent with any of tenant's other stores operating under the same trade name used by the same tenant at the premises and for no other purpose. It does not say we're going to use these solely and exclusively as a flagship store. Flagship is a standard of operation. Section 4.5 of the leases sets forth the standard and imposes restrictions and obligations on the tenant without any obligations and restrictions on the landlord. And I should emphasize that you can't say frustration of purpose for a lease where they're using the premises now for original terms through 2032, and there's 5-year renewal options, so we're talking 2037. These premises are in use. The purpose of these leases was not frustrated, and as a matter of law, you can't apply that doctrine here under the circumstances. This panel, except for you, Justice Renwick, but this panel got it right in 170 Broadway, and the same holding is applicable here.
I don't think you're saying I got it wrong. I think you're
No,
saying I
I'm
wasn't
saying
on the
that-
panel. Is that it?
I'm saying
I was on a
you're not
couple of the other
panel.
ones, though.
But you got it right in the Valentino case, I think. Okay, I'm done.
Smart man.
The lease, the operative paragraph of our lease says 4.5, and it says specifically, tenant agrees that it will operate and design a flagship store in the premises benefiting the unique nature of Times Square. Broadway says that the lessee, the tenant, will have a store that is generally consistent with the majority of the tenant's other stores. Fundamentally different. And if you go to these cases that I was mentioning earlier that
related primarily to Prohibition and World War II. Those cases recognized, in one case, there was a hotel, the Kaiser case, that was being leased to operate, it was a building that was being leased to operate both a hotel and a tavern, and it was a 20-room hotel, and it also had a restaurant. And the court said you could have the tavern, then you've frustrated the purpose of the lease. And there are other cases that we've cited here as well. Kaiser case, Kramer case, others that make that point. And here—
Excuse me, counsel, the apparel that was being sold at the flagship store, was it in any way different than the apparel sold in any of your other branches, with the exception of the address and perhaps the square footage?
In some instances, yes, it is. And secondly, it's not about the apparel business.
I understand. It's bonding between the salesperson and the customer to perhaps buy more Gap jeans. I understand there's a marketing aspect to it. There's a reason why you're paying a premium for being in Times Square. You received a privilege, not a right, because someone else would love to be in the center of the world and be able to sell something. I'm not making light of it, but flagship is, as you pointed out, is a description of a location, but it doesn't markedly change the scope of what the Gaps are all about. They're all pretty much, it has to meet a certain criteria. All the stores have to be handled a certain way. I mean, that's what makes the Gap a unique brand, or Old Navy for that matter. So I don't see how you get around the precedent with respect to frustration of purpose.
Because the precedent, this court, above almost all other courts, and the Court of Appeals as well, recognizes that when sophisticated parties, as were the case here, decide on the terms of an agreement, they reduce those terms to writing, those terms control. And if they wanted to do a standard retail store, if they wanted it to be just like every other Gap store in New York—
Counsel, at 42nd Street, this falls under the normal location. So you pay through the nose, because of the location. That's what makes it a flagship, right?
Well, it's not just—
So if indeed the Gap thought that this was different from all its other stores, other than it's paying triple the rent because of the location, then they should have added better protection in the contract.
They did have the protection. They had the—
Not as good as what they had on 59th Street in their 59th Street store contract. That was good protection. Perhaps they just couldn't get it. It's all about the negotiations.
But
I guess they negotiated what they could, because they knew how to negotiate for more in the 59th Street store.
But the 59th Street store was— the lease in the 59th Street store says the standard retail store. It doesn't say flagship. And my point is—
Counsel, what the lease in the 59th Street store, and you're going beyond your time, and I've given you that, but what the lease in the 59th Street store says is that it is for a governmental preemption of priorities or other controls in connection with a national or other public emergency or any other cause beyond the tenant's reasonable control.
that language does not—
took into account all of those things
Yeah,
that
but
I think would be applicable here.
that language does not appear in this lease at all.
Exactly my point.
That's our
That's
point.
the point.
Exactly
No,
my point.
but if it did, then that would, to excuse performance, right, or to require—
Counsel, all I'm saying is you negotiated for what you negotiated. You're making this one sound exceptional. I understand it has flagship language, but that's what you opted for. Gap is capable of doing otherwise. They didn't, and we've already ruled on this, as I said and my colleagues have said, and Valentino. So thank you both.
Thank you.
VIIMP Miami Hotel versus Highcroft. Counsel, I've given you 2 minutes. Okay.
May it please the Court, Andreas Christou for Appellant, Highcroft, LLC. Your Honors, The lower court erred by particularly enforcing this liquidated damages clause and entering a judgment without taking into account that the respondent's damages were very readily, easily ascertainable.
That's what you contracted for. The contract was very clear, very clear.
I understand that the issue is that the respondent was put into a position that was actually much better than they would have been had the contract been fulfilled.
Well, that's on your client.
And it's your burden here to establish why this clause is not enforceable. So that's what you should focus on.
Right.
Now the 1 minute and 14 seconds.
And that's what that's what the appellant did at the lower level, is that they put forth the information that, in fact, the respondent was able to resell rooms, was able to reuse this event space.
Yeah, but what you said in the contract was because it was difficult to ascertain that, the amount of food, how much they would have, it was just a week before. I mean, not, so they would have, the food purchase, those things aren't easy. A room, that's something, the food, et cetera, that's not easy. You acknowledged it in the contract, as has already been said.
Even with respect to the hotel rooms, however, this is 350 hotel rooms that were now paid for by way of this judgment and that were allowed to
Opportunity to minimize their losses in midway during this entire process. And they chose not to. They knew, they were told precisely what they would be owing if they did not cut their losses at that time, and they chose not to. So why should you be heard now?
Because the court still has an obligation not to enforce a liquidated damages clause where it's putting a party in a much better position than they would have been had the contract been fulfilled. And this contract, now they were able to recover 100% plus the ability to resell rooms and event space, rooms, especially 350 rooms, at probably a much higher rate than they contracted for with my client. So at the very least, there should have been a hearing in order to determine the respondent's actual damages, what they were able to resell, reuse, re-rent those hotel rooms out. It was a couple weeks before, so there was certainly time for them to, they probably did re-rent those rooms. At the very least, the court should have set this matter down for a hearing.
Given it's your burden, I don't see how that how you've met it.
That information was in the respondent's possession. They moved for summary judgment without the ability to engage in discovery. They did not put that information in their motion paper, so my client had no way to.
They moved for summary judgment under the contract.
Thank you, counsel.
Thank you.
People versus, Bullard versus Sheffer.
May it please the court. My name is Catherine Hines. I represent petitioner appellant respondent Jasmine Bullard, daughter of Horace Bullard, as well as the executor of his estate. Horace was a successful real estate developer. He had a vision to redevelop Coney Island. Respondent appellant Peter Sheffer performed some consulting work periodically over the...
We know the facts, counsel.
Sure.
So why don't you explain why this, why what decedent wrote, indicating that he wanted to ensure that the respondent received 5% interest of any future sale of these particular properties. Why don't you explain why you don't think that that's applicable and we should uphold that section?
Your Honor, the letter you're referring to, which has been attempted to be classified as a contract by Mr. Sheffer, memorializes an ongoing oral promise, if you were.
Why is it an oral promise? There's a writing. There's a fairly clear writing that about 5% of the proceeds. He's not relying on the oral agreement. He's relying on the writing. So you have to show why this court should not enforce the writing, which the decedent clearly agreed to.
Your Honor, from the face of the letter, it's a personal promise by Horace in the event that he personally receives the money. The phrasing is 5% of actual proceeds to me, received by me.
Right.
Before he died in 2013, nothing had been done. Neither of the properties had been disposed of in any way. And upon his death, the corporations which owned the properties.
The corporations are always the only ones who could sell that property, though. So why wouldn't the clear meaning of that agreement be the corporations, and why shouldn't it be enforced even past his death? What about it makes it not survive the death of the decedent?
I would argue, Your Honor, that it's actually a personal promise by Mr. Ballard, should he receive money.
Why would he receive the money if the property is owned by the corporations? Why would he be receiving the money personally?
Because he was the sole shareholder at the time.
But he signed the agreement as the CEO of the two companies, Thunderbolt and Wanatabi. I mean, and it's clear that he signed in a corporate capacity.
I would argue, Your Honor, that has not been established definitively. It's clear from the way the letter is written that he's referring to me personally, back and forth, as well as work that has been performed on behalf of the companies.
But you are ignoring what my colleague just said. If these two properties are owned by the corporation, right?
Yes.
Are we wrong about that?
No, Your Honor, they were solely owned by the corporations.
So when he says me, he's talking about the corporation. Because if it were sold during his lifetime, the money would go to the corporation, and then he, as the owner, would be able to do with it what he wants. Right?
One of the properties was,
Right?
yes, Your Honor.
Okay.
One of the properties was not actually owned by either of those corporations. The Shore Theater property is not owned by either of those corporations. It's owned by a different corporation, KFCI. That property was sold by KFCI following Mr. Ballard's death. So that property, that corporation, under that interpretation, is not party to this agreement.
And who was the owner of KFCI?
Mr. Ballard was, but he did not include that. If it's intended to be read that he's signing on behalf of corporations, that corporation was.
Well, he was very specific about which corporations, right?
Yes, and that corporation was specifically not listed.
Okay.
So if that's the case, that corporation and the Shore Theater property would not be party to this at all, because that corporation did not make this agreement, if that reading is enforced.
Wait, in this instance, it's Thunderbolt and Shore Theater properties?
Yes.
Okay.
And the Shore Theater property was owned by KFCI, Inc.
And they're both listed?
Coney Island Real Estate. KFCI is Kansas Fried Chicken.
And it's in Coney Island.
Yes, but it's not it's a separate entity.
I'm a little confused by what you're saying. Weren't the two properties owned by Kansas Fried Chicken, Inc. and Wantonabe? Weren't they the owners of the properties in question?
Yes, they are.
So why, I'm not following what you're saying then, to be quite honest.
I'm
If they're the owners of the property in question, why would it not encompass those properties then? Following our reasoning.
because the KFCI was not cited in the letter agreement.
But he was very clear that the development of the Thunderbolt and the Shore Theater was what he wanted to compensate him for. It was for his work as to those properties. So the fact that he doesn't include KFC, I mean, what is there to do at KFC?
Well,
It's a business, they sell fried chicken. I mean, there was nothing for him to develop there.
I understand, Your Honor,
So
however.
your argument makes, with all due respect, no sense.
I was interpreting what you were saying, Your Honor, was that that Horace's signature above his titles with two companies implies that those companies are a party to this agreement. Is that not what you were implying?
That's not how this works. We ask the questions.
I'm sorry, Your Honor. So if that was how it was being asked, my point was simply that the property that's enumerated was owned by an entity that is not represented or specifically enumerated beneath Mr. Ballard's signature. That was my only point with regard to that.
Thank you.
Thank you.
May it please the court, Anthony Medico, Medico and Associates for the respondent.
So what's your response just to that particular point, that Kansas Fried Chicken, he didn't sign it as the CEO or officer of Kansas Fried Chicken, he signed it as the CEO or chairman of Coney Island Resorts, Inc.?
I know, I actually wanted to start my argument on that point.
Perfect.
The fact is, A, he signed it personally and on two other individual corporations. The issue of Kansas Fried Chicken was never raised in surrogate court, on summary judgment, or in their brief. This is coming up now in oral argument for the first time, which just goes along with all the other ambiguities in their brief that's trying to persuade the court that this wasn't a viable agreement. There's never been any, this is a case that was filed in 2014. It's been 8 years. There never once has there been an issue of who owned the Shore Theater or the Thunderbolt property for that matter in the entire perplexity of the circuit court matter or the appeal before this court. Why this is coming out now, I have no idea, but it has no bearing on the agreement. He signed it on behalf of two corporations and personally, as the court already has considered. Whether he signed it under his corporations and how he owned it, he intended for these two properties, which he owned by either virtually personally or by way of his ownership of his corporations, whichever ones they were, that when they were sold or long-term leased, my client would get, the respondent would get 5% of those proceeds. What the estate has done with those properties is paramount to my client being received what he should be getting under a valid written agreement. I don't know where that argument, that's my response to that argument with regard to who owned the Shore Theater. I don't even have any evidence in the record on.
You're saying it was never argued below, this is the first time?
It's never been argued. And there's nothing even in the record on appeal with regard to who owned the Shore Theater and why it shouldn't be a part of this agreement. Never once. The rest of their brief, Your Honor, it's 50 pages long, 35 pages of it should be disregarded. It's regarding quantum merit, which was not a subject of the circuit court motion for summary judgment. It's regarding an oral agreement and statute of frauds, which we've already said 1,000,000 times in the lower court, and we've agreed to, that my client can only go after the 5% in his written agreement. We've agreed to that. The circuit court actually wrote that in the decision, very clearly. They raised issues of...
Why was the surrogate court wrong about...
To be honest with you, Your Honor, the surrogate court wrote a 12 and 1/2 page decision. The first 12 pages and the first paragraph of the last page attacked all the arguments that petitioner made in their summary judgment motion, and with clarity and with authority discounted every argument they made. And on the respondent's summary judgment motion, it found a valid agreement exists, found no ambiguity, found that all the requirements for a valid contract existed, specifically stated that the petitioner, the estate, came up with no viable evidence to dispute the validity of the agreement. And then on the last sentence of the last page, when everyone who's read this agreement was under the impression that I had won summary judgment, found an issue as to how the agreement, how Mr. Villard intended my client to be compensated as the way my client interprets it. My feeling is that the court must have been trying to determine the value of damages, because if you have a valid agreement, and the court says you have a valid agreement on the four corners of the agreement, it can only be determining damages. Damages was not a part of the surrogate court motion for summary judgment. It was never a part of it. So the problem that I have with what the surrogate court did is, yes, it rightfully denied the petitioner's summary judgment motion, because they've provided no evidence that the written agreement is ambiguous at all and falls short of the requirements of a valid agreement. But on my end, it failed to instill a valid agreement that they have to perform on. I'm perplexed, Your Honor. That's why we cross-appealed, because I can't understand where the court came from on that last sentence to deny summary judgment when it spent the entire written decision saying that my client and I had met all the elements of summary judgment and all the elements required for a valid agreement. The issue before the surrogate court is whether my client has a valid claim against the estate. That's it. The valid claim against the estate is a written agreement. We have non-party witnesses that have testified who are close. Diane Latour was a secretary for the decedent for 25, 30 years. She was a part of that agreement. She filed it. She had conversations with the decedent about it, what he wanted my client to receive, why he wanted to receive it. The agreement sets forth 26 different activities that my client performed for the decedent and why he should get paid, because it never came to fruition. The fact is that the decedent knew that his partner they were partners since 1992. They recognized that since 1992, they had tried to redevelop Coney Island into what they wanted to see Coney Island become a part of. And it didn't come to fruition. Mr. Bullard was getting ill. They came to a written agreement. They took all their oral agreements that they had prior to that and reduced it to writing, changed it from 8%, 10%, whatever it was, down to 5%. He says, these are the two properties. I want you to have 5%. And there is no way that anybody can ever come to the conclusion that Mr. Bullard intended that that contract not be valid after he passed away. It was specifically written so that he knew that he was going to be passing away. He knew he was ill, and he wanted my client to be adequately compensated. The estate has an obligation to do that. The surrogate court should have ordered summary judgment for the respondent, correctly denied summary judgment for the petitioner. This case should go back down to the surrogate court on the issue of damages only.
Thank you.
Thank you, Your Honor.
Your Honor, as to a representation made, there was never a partnership between Mr. Sheffer and Mr. Bullard. I don't deny they worked together for a long time. Mr. Bullard paid and compensated Mr. Sheffer as a consultant.
Why is it relevant whether or not there's a partnership if there is an agreement?
Because I
What's
think
the significance of a partnership?
it implies that there was some ownership over the properties or even gross proceeds, not net proceeds, and this was specifically negotiated as a actual proceeds received by Mr. Bullard. Had there been a partnership, there would have been a different entitlement because he would have had an ownership.
He's asking for 5% of the proceeds of these properties when they're sold. One's been sold, and I think one
Has not been sold, Your Honor. The other one is a portion of it has been taken by eminent domain.
That's right, and there was an amount of money given as a result.
Yes.
So that's what he's asking for. There's no partnership. He's asking for the 5% of those proceeds.
When he filed his claim in 2014, nothing had been sold and nothing had been taken by
Okay, but it
eminent
has
domain.
now. That's what our focus is, the 5% of those proceeds.
I would argue, Your Honor, that the eminent domain is not clearly a sale. It's a forced sale, and this
A forced
agreement
sale,
is
it sounds
very
like you used the word sale, though. That's what I heard.
Yes, forced, not a market sale.
I think the key is sale. There was,
Your Honor.
yep.
As to the agreement or the decision by the judge, I will state that it's misleading to say that she did not find we found a prima facie case. The final page of her decision states the prima facie cases presented by both claimant and movement are sufficient to warrant denial of the motion and cross motion. And she stated that there was a question as to whether the decedent intended himself to be bound as interpreted by the claimant. With that question outstanding, I don't see how the court could find that there is an enforceable contract with no ambiguities. Thank you.
Thank you both. People versus Michael Pittman.
Good afternoon, Your Honors. Harold Ferguson for Appellant Michael Pittman. I will recognize that I am playing the role of Don Quixote here, tilting at windmills. Nearly 30 years ago, I convinced the Appellate Division's Second Department to invalidate these type of conditional pleas as an illegal form of interim probation. My response after that was getting criminal defense attorneys throughout the state calling me to castigate me for making their lives more difficult. And then I got the drug treatment centers calling me to excoriate me for taking food out of their children's mouths. But the legislature fixed it. They made these pleas legal, and as much as I would love this court to invalidate them categorically, I know you're not going to. Well, what I'm asking this court to do is to impose some sort of standards to make these type of pleas fair, just, and equitable. My client is a middle-aged man who had a 30-year drug addiction and enters a conditional plea without the necessary information to make an informed decision. The necessary information was, what is the statistical possibility
Maybe, you know, a more realistic way for you to achieve what you want is to educate the defense bar.
I have tried.
In the statistical, because your arguments, you know, are somewhat persuasive, but we do have the statute, you know.
You do have a statute, but what I'm saying here is, how can someone like my client make an informed decision when he's missing necessary facts?
It's like when bail gets set after a plea and the defendant says, I have to go home because I want to see my girlfriend. And the court sets bail or paroles them knowing that they're never going to come back.
That's true, Your
That's what
Honor.
you're arguing.
That's essentially, you are absolutely correct. That's what I'm arguing. What I'm saying is, what should be presented to the defendant, here are your two choices. One, you can take the standard plea, this is the prison you're getting now. Or you can take this conditional plea, where you have a better chance of riding a unicorn and being struck by lightning than to complete this program.
That's not quite, you know, the statistics show that it takes 2, 3, 4 times for a drug program to really work for a defendant. So it's not really a unicorn.
But
there
Your
is
Honor,
hope in many instances for help for people.
And there have been a couple of unicorns every now and then.
There have been, but that's exactly the point. If you look at the websites,
A couple,
look at
a
the
very
the websites of these drug treatment programs, there is no statistical analysis given there. They provide anecdotal stories of success stories, but they don't say what are the possibilities. And for
Counsel, except that I can't imagine that good defense counsel are not, and I can say that from experience, right, are not counseling their clients about how hard it is to actually complete it,
well,
to get through these conditional sentences without getting pinched again. They get that counseling, and I would venture to guess that 95% of the time, the client, even when they know that they are likely not going to be able to get through it all, say, I still want the program.
I do understand that, but we're asking,
I think what you're asking is that from a due process perspective, the client is perhaps, I don't know if entitled is the word, but they at least should hear it from the authority meting out the sentence or the punishment that this is going to be very tough. Whatever the statistics are, people are brought back and they end up doing the 2 years. Are you prepared for that? Or whatever it is that comes out.
Right.
That's what you're asking.
That's exactly what I'm
I think.
asking this court to do.
But you're asking us to put it in the decision.
Yes, I am asking you to put it in the decision.
That's where, I don't
again-
think it should just be the defense attorney. Frankly, I think everyone in the courtroom has an obligation, including the prosecutor's office, to make clear that that is stated. I don't know that it will amount to a hill of beans because a defendant who wants out wants out.
I will point out that in New Jersey, one of the first drug courts was in Union County. The main public defender in the Union County drug court was a former addict. And whenever these type of conditional pleas were offered, the court would ask the public defender, what are the chances that this person could complete this program? And he would take that into consideration as to whether to accept the plea. And I don't think New York City should be behind Union County, New Jersey. Okay, thank you, Your Honor.
Thank you.
You're going to get a lot more calls.
Always enlightening to hear from you.
May it please the court, Amanda Regan on behalf of the people. Addressing quickly the validity of the plea here, there's no question that the plea was valid, and defendant doesn't dispute that he failed to preserve his claim that the plea was invalid. Addressing specifically the advisements that defense counsel
is arguing should be made to defendants, that is part of the conversation that should be happening between defense counsel and a defendant.
You have no responsibility in that? You, as an officer of the court, as the person offering the sentence, has no responsibility from the prosecutor's office to say, here is what we are offering. It is so unlikely that you're going to complete this, and we all know that you're coming back in 35 days and going to jail for 2 years. You have no responsibility to make that clear? Not even a little bit.
I do think that that was made clear.
When was that made clear? I don't know that I've ever seen a...
The judge advised the defendant of what the ramifications if he was unsuccessful.
The ramifications being if you are unsuccessful, not there is an extraordinary likelihood that you will be unsuccessful. And what I asked you was, do you feel that you have no responsibility as the prosecutor when you offer that plea to make that clear? None at all?
Your Honor, those were possibly part of conversations happening during plea negotiations, but they were not made on the record. And here...
You didn't answer my question.
Your Honor, perhaps more people in the courtroom should be advising defendants, but that does not undermine the validity of the plea. And here, there was a representative from...
You had said you moved on from that issue. That was your first point. You said you had moved on to the second point. I thought that's the one you were talking about.
And I'm addressing the second point. There was a representative from the drug program in the courtroom who presumably evaluated the defendant and evaluated his earnestness in participating in the program. I think that here, specialty courts have never made such advisements. And as I said, this is a conversation that needs to happen between defense counsels and defendants.
Except that it is so much more powerful, right? When a judge says to a defendant...
I understand that, Your Honor, but
I'm not finished. When a judge says to a defendant, this is really hard, and I've been on this bench for a number of years, and I've only seen a handful of defendants who've taken this plea actually be able to complete. I want you to really think about it, because you're going to add on more time if you fail at this program. Talk to your attorney. That's not asking a lot.
I understand that, Your Honor, and I see my light is on. If I may briefly just address that. Yes. The reason that providing statistics is difficult in these situations is that achieving sobriety is up to the individual. It's whether or not they are ready and willing to take that next step. And they, as one of Your Honors has pointed out, it often takes multiple times. And here the defendant was given multiple chances and actually did complete a significant portion of both drug treatment programs. And so that demonstrates that he was ready to take that step. And if defense counsel's representations in the reply brief are accurate, it sounds like he has achieved sobriety, and that's wonderful.
Well, are these programs really offering sobriety, or are they merely offering a substitution called Suboxone or other such drugs created by these massive drug companies?
I don't know what the individual circumstances of defendant's situation was, but sobriety, of course, is one of the goals. And when an individual is ready to take that step and they would like to participate in a Manhattan drug court plea, then these conditional pleas should be allowed and should be valid. And here...
But you know, we're not playing, I mean, it's not a game here. That's not what people want to do. That's not what the prosecution wants, I'm sure, either. So full disclosure, as Justice Renwick has mentioned, really should be the goal, so that the defendant knows what they're getting into before they do it.
And I understand Your Honor's point, and it's well taken, but that is a conversation that should be happening between defendant and their defense counsel and the representative from the drug court programs about the likelihood of success. And here we have every reason to believe that those conversations did happen because there was a representative from the drug court program in court who certified on the record that defendant was going to be taken that day to a treatment facility and that he had been evaluated. So we have every reason to believe that that conversation did happen. The fact that it didn't happen on the record does not undermine the validity of his plea. And unless Your Honors have any other questions, we ask that you affirm.
Thank you.
If anyone who has the statistics, it has to be my adversary. All it is, these are the number of conditional pleas taken in the Manhattan Drug Court this year. These are the number who successfully completed the program. We're not asking for, a fantastic thing to be done. It's simple statistics. And if the current Manhattan District Attorney is talking about the goal is to try and defeat addiction, it took my client over 8 years to do this. If the goal was to defeat my client's addiction, he did it. It took 8 years. And what we would ask this court to do is reward him for doing that and to vacate this plea so that it is expunged from his record. That's all we're asking for. Thank you, Your Honors. Have a great day.
Thank you. Thank you both. Winkler versus Hallmark International.
You may proceed.
May it please, good afternoon. May it please the court. I'm Scott Winnico from Donovan Hatem, representing the appellant J.A. Underground. The evidence submitted to the lower court in connection with J.A.'s motion for summary judgment establishes that J.A. bears no liability for plaintiff's death. J.A. had a limited role in the project. It provided 2 employees to the project. Ed Sturmer was the assistant resident engineer, and Mike Hadley, who was one of the inspectors for the job. The other inspector, Craig Morgans, was an employee of co-defendant Hacks. J.A. was a subconsultant to Hacks who was hired to be a resident engineer providing construction management services. Pursuant to Hacks' contract with DEP, J.A. had no responsibility for the means, methods, and safety procedures of the contractor, Halmar.
Isn't there evidence in the record that it had the ability to stop the work if unsafe conditions were occurring? And isn't that the question we have to look at to determine whether it has liability as a statutory agent?
No, there is no evidence. There's an allegation that that's what happened, but there is no evidence to actually support that J.A. had the responsibility to stop the work if it observed
Authority. There's now a much more, I know that initially summary judgment was denied, but since that time there's been extensive discovery, depositions, et cetera. Isn't there now actual evidence in the record that J.A. did have authority and the ability to stop the work?
No, there is no evidence that supports that J.A. had the authority.
Wasn't deposition testimony of a Mr. Sturm, who was actually the point person on the ground, who actually said that they had the authority to stop the work, and he did do so in the past?
Mr. Sturm said if he observed something, he could possibly stop the work if he observed a hazard. He wasn't on site.
He personally said that he had done so on more than one occasion.
Yes, but he was not at the location where the
Yes, I
accident occurred.
understand.
Because he chose not to be. You know, this is the second appeal in this case that I've been on, and I have to tell you, reading it for the second time is even more shocking than reading it for the first time.
Mr. Sturm had no responsibility whatsoever to be at the Maybrook site the day of the accident. There's allegations that he was supposed to, but there was no responsibility for him to be there. Who was supposed to be there was the resident engineer, and that was someone from Hacks.
Wasn't Sturm responsible for preparing a notice to place? And that was not done here?
No. He did prepare a notice to place. He did submit it. The purpose of the notice of place was to make sure that the concrete inspectors would be at the site for the concrete pour so they can test the concrete. It has absolutely nothing to do about the inspection, about whether or not the formwork was built correctly. He did his job. It wasn't submitted. He had to go and he had to take some effort to get it, but he got it done. He was able to get the concrete inspectors there. He was not supposed to be there on site. The person that was there was Craig Morgans, who was an employee of Hacks, not J.A. He was on the site, not my client. If my client's not on the site, how can he stop the work? He wasn't there. He didn't observe anything. And there's no evidence that, there is absolutely no evidence in the record that shows that any inspection would have caught the defects that occurred. There's no expert testimony in this case. The only there's an expert report that places responsibility for the collapse squarely on Halmar. Halmar had the obligation and the responsibility to supervise the installation.
So nobody after JA warned the city supervisor that he did not believe the formwork was complete. It was nobody's responsibility to check that before the concrete began to be poured and these two men were crushed.
We did our job. We warned them that we had a concern. We did our job. That's what we're supposed to do under our contract. We warned both Hacks, Halmar, and the city that we were concerned. We were overruled. What else could we do? We brought our concerns.
I hate to use a poor analogy of I must follow orders. I mean, Stern was an engineer. He knew that there were problems, but to say I'm not going to exercise my responsibility and authority because Halmar or they want to keep the project going because they're dollar signs, there's cost overruns or whatever rationale makes no sense to me.
Sturm is not a professional engineer.
He could have exercised his obligation to stop it as he did it before. Even though he was not there that day, he got reports that Morgan and other people there heard the forms were, something didn't sound right. They were concerned about the stresses being done on the form for a potential collapse.
Mr. Sturm never got that warning about anything. There's no evidence in the record that Mr. Sturm was notified about any issues with noise or anything. Mr. Morgan did call and he spoke to him, Mike Hadley. He never raised any issue about any structural stability. He said he heard a noise, the noise was quickly corrected. Okay, but there's no evidence whatsoever that Mr. Hadley was told that there was a creak, that there was a potential, that the installation was not done correctly. He did what he was supposed to do. He raised a concern to the commissioner. That was what was, to Mr. Lovely. That is what is required under the contract. He fulfilled his contractual responsibilities.
Okay.
If others disregarded him, that does not cast liability onto us.
Thank you. You'll have time on rebuttal.
Thank you.
Who's next? You may proceed.
Thank you, Your Honor. Jonathan Schaub for the Halmar respondents. I think that this court has hit on the key issues of just how involved JA was in this pour. But to reinforce the point, there were contractual provisions in this case that gave them the authority to supervise and control the performance of the work. They also had the authority to report dangerous means and methods to the city, and they had, as this court noted, stop work authority. Turning to the notice to place, which this court has correctly identified as an important issue, the notice to place was only to be filed after it had been confirmed that the inspections that were necessary had been performed. Those inspections, it's clear in the record, would have uncovered or were directed at the issues that actually caused the collapse in this case. That relates to the support system and the number of anchors that were installed. As my colleague noted, there were inspectors in this case. One inspector was employed by JA, one was employed by Hacks, and both reported to JA's Ed Sturm. Those inspectors were supposed to look at the formwork before concrete was ever poured to confirm that it was built in accordance with the designs and the structural plans. That was not done in this case. So again, this is evidence of authority to supervise and control.
Sir, do you believe that Halmar is entitled to common law indemnification here, given an earlier finding that they were actively negligent?
Halmar cannot, that would not be, given the negligence finding that's been affirmed by this court, that's not on the table, but contribution is still.
And did Halmar challenge the challenge to its claim for contractual indemnification?
Halmar's claim for contractual indemnification, no, it did not below. But then just turning back to the issue of what happened on the day and the events surrounding the pour, when, as this court noted, when the pour was first suggested, Mr. Sturm, who was a JA employee, noted that there were safety concerns. turning to the events right before he filed the notice to place, he filed the notice to place despite knowing the fact that the formwork had not been completed and therefore it had not been inspected. He sent the inspector to the job site on that day. That inspector failed to actually perform the inspection work he was required to do. And then as to the issue of the noises, the HACS inspector called the JA inspector and said, I've heard a creaking noise and I noticed that there's lateral bracing missing. And could you look at the plans and see if this is required? That was not done either, and the pour was not stopped by JA at that point. It was not stopped by HACS at that point. And in fact, the lateral bracing was one of the things that the reports, OSHA called out as being a cause of this accident. So again, we have authority to supervise and control and the exercise of that authority in this case. To one last point, just briefly, there's a Labor Law 200 claim in this case. There's obviously, the JA moving for summary judgment has the burden of disproving both theories, means and methods, and dangerous condition. No argument was ever made as to the dangerous condition, so obviously they wouldn't be entitled to summary judgment on that claim. Unless the court has any other questions, we would rest on our brief.
Thank you.
May it please the court, I'm Carl Lustig. I represent the plaintiff Winkler in this case. There's some facts in this case that are a little different than what was just presented to the court. Ed Sturm, who was the senior man for JA on this job, who was the assistant resident engineer, absolutely knew for a fact that the formwork was not done. It had not been completed. He also knew that the rebar within the concrete itself had not been completed and wasn't properly done. He had seen photographs. He knew full well that the formwork was not ready for the concrete pour that was ordered for December 2nd. What did he do? He still issued a notice of place, and effectively what he was doing was rolling dice, hoping that they could do this pour and get away with it, that it would be okay, and they'd strip it and nobody would be the wiser. Unfortunately, in rolling the dice, he lost, and 2 men are now dead because of it. Now, to make matters worse, Maybrook, New York was a separate location from the main job, which was being done in Gardner, New York. All the evidence in this case makes it very clear that Maybrook, New York, as far as the aqueduct project was concerned, was effectively the redheaded stepchild. It got short shrift, it did not get the attention, it didn't get the inspections, and when every pour that occurred in Gardner, there was a checklist, and the checklist is in the record, at the supplemental record 2697. It's a comprehensive checklist that the inspectors, whether it's Mr. Morgan's, who worked for HACS, but was dispatched to do this inspection by Mr. Sturm. He was there under the authority at the direction of Mr. Sturm. So for counsel to say that he was employed by HACS, that is absolutely, it's irrelevant, and it's misleading. But that said, he was sent to Maybrook without the checklist. This is a port that's going on without the checklist. The checklist is, it has HACS on top of it, and it's required by the construction manager, which is HACS and JA Construction. It requires that there's a verification by the inspector that the drawings for the formwork are available at the site. They were not. Mr. Morgans had to call back to Gardner and spoke to Mr. Hadley to ask him questions about the designs which were there. It also required verification that the formwork was inspected by a competent person and the shores are installed per the shop drawing. The shores were not. There are missing braces, and of course there were no shop drawings for him to compare it to. The checklist also requires, and inside each one of these are line items that the inspector is required to initial, that they confirm that it occurred.
There was no checklist this morning, on that morning, correct?
That is absolutely correct, Your Honor. This checklist, the checklist that was required for every pour, required that the inspector monitor the pour as it's taking place. Mr. Morgans, while the pour was being placed, was sitting in his car having lunch. Now, again, while Mr. Morgans certainly bears more than his share of blame, the fact remains that Mr. Sturm sent him to this site without this checklist because he knew that the work had not been completed. Additionally, the checklist requires that the rebar is installed properly. Well, that would have been checked by the inspector had the inspector had this checklist. The problem is that Mr. Sturm already knew that it was not. And of course, that's why he couldn't send the checklist with Mr. Morgan's to the job site. There's a multitude of other things there. It's in the record that would have been checked, that had it been checked, this pour would have been stopped. Mr. Sturm did not warn anybody about this problem. He was vague about it, and in fact, when he had that opportunity in an email to Chuck B, we call him Chuck B because I can't pronounce, none of us can pronounce his last name.
Buryanovich, something.
That's close. That's as close as anybody's gotten, Your Honor. He was the resident engineer. He was the man who was above Ed Sturm. Ed Sturm was the next guy below him. He sent him an email in advance of the pour after he knew that the formwork and the installation had not been completed properly. He sent him an email and didn't mention it. He withheld that information from the top guy on the job. Now, Mr. Sturm admitted that he had the power to stop the work if indeed he saw something that required the work to be stopped. Certainly, you cannot imagine anything more dangerous, anything more worthy of a work stoppage than the problems with the form and the problems with the rebar in this pour. And of course, in retrospect, with the benefit of hindsight, we know how devastating that was. And incidentally, that explains the outrage of Judge Nervo. Judge Nervo was appropriately outraged.
Thank you.
You have Mr. Sturm, who abdicated completely responsibility that he had on this job for this pour.
Thank you, sir.
You're welcome. Thank you.
Good afternoon, Your Honors. Christopher Roberta from Cerusian Spring on behalf of the city defendants. I just wanted to emphasize, excuse me, the other parties covered a lot of what I was going to say, so I just wanted to emphasize two things. One, with regard to inspections by J&A, as the lower court correctly determined, Mr. Sturm did affirmatively attribute to J&A, albeit on the shoulders of his co-employee, the responsibility to assure the formwork was completed. And with regard to the telephone calls that were going on at the time of the concrete pour, it hasn't come up yet, but those concerns that Mr. Morgans called Mr. Hadley with, Mr. Hadley actually relayed those concerns to Mr. Sturm. And Mr. Sturm, being aware that it wasn't ready, having seen the photographs, having seen the progress reports, he didn't take any further action when he got that phone call. So to say he wasn't on site, he couldn't have done anything, I don't think that's fair, Your Honor. He could have been on the other end of the phone and say, stop that pour. We know that it wasn't completed. And if the court doesn't have any questions for me, I'll be done.
Thank you.
Thank you.
Your Honor, I get the outrage over this accident, okay? It's a tragic accident, and I get that. But my client bears no responsibility for this. They were not there. There was never any discussion to Mr. Sturm about the creaking, and all that was told was, all that was mentioned by Mr. Morgans was that there was creaking, and that the issue was resolved and the creaking had quickly stopped because they tightened the bolt. Mr. Morgans is not a JA employee. He's an employee of Hacks. There's ample evidence, overwhelming evidence in the record that Mr. Morgans did not report to Mr. Sturm. He reported to Chuck B. Chuck B was his supervisor. Chuck B was supposed to train him in what to do. We did not send Mr. Morgan to the site without the pre-port checklist. He didn't bring it. That's different. We didn't tell him not to do the pre-port checklist. We didn't know. He never told us that he didn't do the pre-port checklist. But there's also no evidence in the record that establishes that had that pre-port checklist been performed, this accident could have been avoided. And that's why Justice Chan denied the motion the first go-around. You have to remember, this is the second time. The plaintiff made two motions for summary judgment here. They had all the evidence they needed the first time. Justice Chan denied their motion the first go-around. and then they were given a second opportunity before another judge. And that's not proper, that's incorrect. Mr. Lustig, Winkler's counsel, did not appeal that decision from Justice Chan because he knew it was a correct decision. There was no new evidence that was submitted in connection with the second motion.
I'm sorry, but there was continued discovery after the issuance of Judge Chan's order, correct?
There was some
Because she determined that there was an issue of fact as to whether JA was a statutory agent. So it had to be fleshed out, and then we had more depositions of Sturm et al., correct? The very depositions which you rely that are necessary for your position.
None of the discovery that happened after the decision was issued was even raised before Judge Nervo. The only depositions that took place after the decision was raised was William Loftus, who was Halmar's inspector, who was supposed to supervise the installation, not J.A. or Hacks, and Chuck B. None of that testimony was submitted in connection with J.A., so it's irrelevant. Mr. Sturm's deposition was completed months before oral argument. It was completed before Winkler submitted his reply papers. If there was any testimony that came up with that second deposition, they could have submitted it the first go-around. That was not new evidence. Mr. Hadley was deposed. Again, Mr. Hadley was deposed before the decision was issued.
Thank you. Thank you. Thank you all.
Thank you, Your Honors.
Drone USA versus Antonilos.
May it please the court, Daniel Liebersfeld on behalf of the appellant, Dennis Antonellos. I'll start with my client's claim for his counterclaim for his unpaid salary. There is really no meaningful dispute here that my client met his prima facie burden on summary judgment with respect to that claim, in the sense that Drone and Mr. Bannon repeatedly admitted in discovery and admitted to the SEC that my client was owed $90,000 in salary that he had not been paid. So obviously the burden shifts to the plaintiffs to show that there is an issue of material fact. And on the motion, at the motion court level and on appeal, the basic argument there is Section 3A, which supposedly grants the company the right to defer any cash payment until it, quote, has sufficient funds to do so. Now, this argument fails at multiple levels. First off, the defense wasn't raised until their opposition brief on motion for summary judgment in the court below. And, again, they never told the SEC that, sure, we owe Mr. Antonellos this money, but we can defer until we have the money to do so.
And in the interim, Mr. Bannon paid himself back $400,000.
Well, that's not all. Apparently, he paid himself, at least in his annual salary, is $624,000 a year. And he didn't just pay himself back on that promissory note, he paid himself back with interest. That argument also ignores Section 5B of his employment agreement, which says, and I'm leaving out some of the unnecessary verbiage here, it says, in the event that executive's employment with the company is terminated during the employment period by executive, the company shall pay executive any earned but unpaid salary. Now, if there was some right to defer payment after the termination of Mr. Antonellos' employment, it could have said something to the effect of, except as otherwise provided in this agreement. It could have said subject to the terms of Section 3A, but it doesn't say that at all. And finally, there's actually no showing as a factual matter that the company lacked the funds to pay him. And, regardless of whether Mr. Bannon has paying himself, hundreds of thousands of dollars instead of my client. The sole evidence we get in response to the summary judgment motion is 2 sentences from Mr. Bannon's affidavit. And that says, quote, "At the time of Antonellis' resignation, and since, based on the cash available to Drone, and in my determination as CEO, Drone did not have sufficient funds to pay Antonellis' salary. Copies of Drone's annual reports for 2017 to the present are attached here too as exhibits Q to T." Now that's it. Now I'm sure everyone has seen an SEC filing before, and these are hundreds and hundreds of pages each, and that's why my adversary stipulated to omit them from the reproduced record on the grounds that they were excessively bulky. So it's the same way as you can't create an issue of material fact by, it happens with experts where, say in a med-mal case, an expert says, well, if you look at all the medical records, those show that, the standard of care was breached or it was not breached. You have to explain why that's the case. And I just want to go to the indemnification point real quick. And I'm with all due respect to Mr. Cronin, I'm still at a loss to say how the bylaws that they claim apply don't provide for any indemnification when I've pointed out to the motion court and pointed out in my opening brief, section 13 of those bylaws, which are materially indistinguishable from the bylaws that Drone filed with the SEC, and that it is titled indemnification. And it says that they shall indemnify my client by reason of the fact that he was an executive or employee of the company. So again, for the life of me, I'm still at a loss as to how they can claim that there is no indemnification provided for in the bylaws. And then finally, one of the very cases they cite, the Dorr case from the Delaware Court of Chancery, actually says that when the company asserts claims against a former executive and the executive succeeds, the executive should be indemnified for his or her attorney's fees. And that is exactly what happened here, as it was Drone and Mr. Bannon that sued my client. Those claims were dismissed on summary judgment, and Drone and Mr. Bannon dropped that cross appeal. And I'll yield the rest of my time. Thank you.
May it please the court, Gregory Cronin of Blank Rome for respondents Drone USA and Michael Bannon. On appeal, Mr. Antonellos asks to rewrite both his employment agreement and black letter Delaware and New York law. As to the employment agreement, Mr. Antonellos is awarded compensation pursuant to Section 3. The language of that section states he is awarded the compensation provided, however, and those terms are underlined in the agreement, the company may elect to pay such salary in cash or stock. Similarly, counsel for Mr.
Why don't you address the issue that your adversary raised concerning the language concerning termination? Because it seems to me that that is the applicable language here.
Your Honor, the opposing counsel left out a word. He said there were some unnecessary words there. However, Section 5B of the agreement in termination, this is on record page 171, states the company shall pay or grant. The or grant language is reflected.
Is the issue before us whether it should be stock or whether it should be cash or whether it should be paid at all? I mean, I thought that the issue that we have to determine is whether the unpaid salary shall be paid, not in what form it shall be paid, which is what you seem to be arguing. Isn't that a different issue?
Yes, Your Honor, there are two issues here, because after the court denied plaintiff's claim.
What's your argument? Let's focus on what is your argument as to why he should not be paid, whether he's paid in stock or cash. Why shouldn't he be paid?
Drone has paid Mr. Antonellos and issued shares to Mr. Antonellos after its claims were denied, representing not only his compensation, but 9% interest. Mr. Antonellos rejected the shares and said, the shares aren't worth enough. I want cash. The agreement allows the company to pay his salary in stock.
Well, isn't it a factual issue then whether the amount of shares you offered equals the amount of salary that should go to a hearing? Assuming amount is owed, doesn't a determination then have to be made once the court determines an amount is owed, whether a sufficient amount has or has not been paid?
Yes, Your Honor, and that is what the lower court found. Justice Crane stated that there's a material issue of fact in the payment of salary, whether he's owed stock at the very least,
But
or whether...
why then doesn't he get summary judgment on liability and it just go to a hearing on whether the stock you're offering is of a sufficient value to satisfy the undisputed obligation to pay? Why does the litigation go on?
Because Mr. Antonellos rejects the idea that he can be paid in stock altogether and claims that this...
He rejects that the stock is worth the amount owed to him. And why is that not, as my colleague continues to ask, why is that not a matter that should go back for a hearing to determine? Because it seems to me you have acknowledged, your client has acknowledged, owing the amount of unpaid salary, correct?
Yes.
There's not an issue about that.
Correct.
And that amount is $86,000 and some odd dollars, right?
Correct. And we've acknowledged that there should be interest on that as well. But Mr. Antonellos does not accept the form of payment. If it was just about amount, I would agree completely, Your Honor.
So why isn't that, and look, I mean, whether to give me paper that is worthless doesn't make me whole, right? So why is he not entitled to a hearing to determine that the stock that your client offers actually is worth the paper it's written on?
Because that would be a question of interpreting the ability under the agreement to pay.
No, it's a question of determining whether he is being made whole for the value he is due.
So the idea is, under your theory, you can give him stock, and the stock could be worth 3 cents each, and that's okay, because he got stock?
The parties negotiated this agreement in a startup.
Is that, yes,
Yes,
that's
Your
what
Honor.
you're saying?
Yes. If the value of the shares...
That answers a lot of our questions.
Why isn't the only, I mean, I don't know why we keep asking this, why isn't the only reasonable interpretation of the agreement that, yes, you could give stock, but if you get stock, it has to be worth the $86,000?
Yes, and they issued 36 million shares
But we
representing...
don't know whether that's worth $86,000. You're saying it is, he's saying it's not, and why shouldn't that be determined?
If you've accepted that form of payment, yeah, I completely agree, Your Honor, but there is a dispute, and I'm sure Mr. Lebersfeld will raise it, as to whether or not the company can even issue the shares. And he states that it's an illusory, it's an unenforceable contract because these terms were not indefinite enough, and because of that, the contract is unenforceable, but he should be paid in cash, in hard cash, and that's not what's reflected in the language.
Well, your client was paid in cash, why shouldn't he?
The terms of my client's employment...
Why shouldn't he?
Because his agreement allows him to be paid in shares or cash. That is what is set forth in his employment agreement and what he agreed to. On to the issue of the indemnification, Mr. Lebersfeld fails to reference the fact that these were claims related to a personal guarantee.
No, he was signing, excuse me, I understand that the signature line didn't have the title by their name and your... But there's no doubt that this was a corporate guarantee, that he was, based on this record, he was pretty much told by Bannon, we need to give this guarantee so that this Farah guy can come on board, and otherwise the company will experience a loss, whatever it is, in not getting this valuable employee. He did so, even if he doesn't have his exact title by his name, but it was a corporate guarantee. And he was signing it, and the actual thing, I believe, when I last looked at it, the other signature line identified Mr. Bannon as the CEO of the company on the right-hand side. The left-hand side has their signatures, in an individual basis, but the totality of the document suggests it's a corporate guarantee, and he was doing so in his corporate capacity as the CFO. He joined the CEO in guaranteeing so this guy's valuable employment contract can be honored.
I see that my time is up, if I may answer your question briefly.
You may. I'm sorry.
The guarantee is reflected on page 165 of the record, and there is a section entitled Corporate Guarantee. However, it is a strangely written guarantee, but right above Mr. Antonellos' signature and right above Mr. Bannon's signature, it says personal guarantee in all capital letters. The agreement has this guarantee by which the company has an obligation for a certain period of time, And if the company fails to meet that, these individuals have an obligation. Delaware law and New York law is clear that their personal contracts, personal liabilities are not indemnifiable by the corporation. Every guarantee in New York law would become nothing. A landlord who guarantees his rent would say, oh, well, I really only entered into that guarantee because I was the landlord for or because I was representative of the company. A personal guarantee is a personal obligation. It says it on the paper. That's what it is. Under New York law, Delaware law, it is not indemnifiable as a corporate act. He was acting as an individual when he personally guaranteed and had personal liability. Thank you, Your Honors.
Thank you.
I'll start real quick with the indemnification point. It's not relevant whether the guarantee is a personal obligation in a literal sense. Delaware says the issue is whether he was sued by reason of the fact that he was an executive of the company. So if Farrow had gone after my client on the guarantee, then Mr. Cronin's argument might have some weight. But the company and Mr. Bannon sued my client. That suit failed. So under Delaware law, my client is entitled to be indemnified for his attorney's fees. And if I could turn real quick to the stock tender. The tender of shares was made after the summary judgment motion was adjudicated. Before that, the company admitted that it had never tendered him any shares. But even so, the agreement, it does not set forth a formula by which he can be issued shares in lieu of cash. And the exact issues the panel is raising demonstrates why. Well, what if the stock's worthless? What if the stock is worth 1 cent today and it's worth less than a cent, a week from now? So he's not going to be adequately compensated. So typically, you have stock option agreements where the employee has the option to purchase shares at a set strike price. And that's how you fulfill that argument with an agreement like that without the obligation being illusory. And I will yield the rest of my time. Thank you.
Thank you, sir. Thank you both. Okay, the last case is Gill versus Calfee. Justice Mazzarelli is recused from this case.
Good afternoon, Your Honors. My name is Dan Ratner. I'm from High Delta, Tony Murphy and Bach. I represent New York Presbyterian Hospital defendants in this case. The patient was discharged from New York Presbyterian Hospital on antibiotics on March 22nd, 2013. The plaintiff was not seen again, or my client was not involved in the care and treatment again until 6 days later when a phone call came in. In the meantime, the very day that the plaintiff was discharged, she received her intravenous antibiotics from a home infusion service that night. Prior to discharge, she was warned in a discharge summary about the potential side effects of nausea and vomiting. That night, when she received her first IV infusion, she was again warned. She was given a monograph about this type of drug, gentamicin. The following morning, as she was instructed to do, the plaintiff contacted her local physician up in Kingston, Dr. Van Roisner, who's not a party in this case. Dr. Van Roisner's partner got involved in the care and that morning, and then again that afternoon, until the patient went to Kingston Hospital Emergency Department complaining of the same symptoms. Dr. Van Roisner received the discharge summary on Monday morning. So by this point, Monday morning, 3 different caregivers were aware that the plaintiff was on gentamicin, and they understood the symptoms that she was experiencing. New York Hospital, the claim against New York Hospital was about the handoff, the nature of the handoff. Now, we know that there was at least one telephone conversation between a physician, Dr. Isa, at New York Hospital, and Dr. Von Roisner, the local physician up in Kingston. There's some dispute about whether there was a second conversation, but we know that there was one. We also know that Dr. von Reusner had experience, monitoring patients on this antibiotic. Now, of course, he downplayed it a little bit, but he knew that if there was a side effect, and he admitted this in his deposition, that he had to treat it. And he was made aware of the side effect of vomiting and nausea while the patient was under his care. So now we argue the issue of legal duty and things like that, but the bottom line is that any treatment by New York Presbyterian Hospital was so attenuated from the ultimate outcome that there's no way that there's a tribal issue pertaining to my client. The fact is that the patient was warned at least twice in writing about these side effects, and three caregivers in the interim were aware that she was experiencing the very side effect that she was warned that she should call her doctor about. It's as simple as that. So unless the court has any questions, I will rest on my brief.
Thank you.
Thank you.
Good afternoon, Your Honors. Juan Gonzalez for the appellant, Dr. Gina Petrito. I think the issue, excuse me, I think the issue as to Dr. Petrito, who is an emergency room physician in Kingston, New York, at Kingston Hospital, is whether or not on this motion, the motion court improperly credited the plaintiff's emergency room physician and expanded the limited duty of care for an emergency room physician. That's number one.
Why wasn't there some obligation on the part of the physician in the emergency room to at least, if not consult with the initial hospital, consult with a doctor in her hospital, an infectious disease doctor, about the significance of these symptoms and what should be done?
Well, it's a good question, but I think it begs another question, which is what was clinically indicated and what was shown on the labs that would have put any emergency room physician who was tending to emergencies on notice that there was something concerning. There's been no evidence in the record whatsoever about any emergent situation revealed by the lab work on 3/23/13 whatsoever.
Well, let me ask you, and that is, those lab results were inconclusive. Is it enough that this emergency room doctor knew this patient was taking this drug that had these possible side effects and was presenting with vomiting, which could engender these subsequent side effects? Was that enough to trigger a duty on the part of the doctor to at least refer her to an infectious disease doctor or not?
And that's exactly what happened. So Dr. Petrito treated the symptoms. She kept her in the hospital for as long as it was necessary to stabilize the patient. She tracked her almost every other hour or every hour as to her condition, and they progressively improved up until the point around midnight. They fully resolved.
Yes, and I recognize that Dr. Petrito was treating her for the symptoms of nausea and vomiting with Zofran and liquids and et cetera to stabilize. And yes, I'm mindful of the fact that there was a slight bun increase or creatinine increase from the normal range, arguably attributable to dehydration from vomiting so violently as described in the record. The question is whether the doctor had the ability to consult and determine whether it was necessary to give her the antibiotic that night in light of the clear side effects that were being experienced by the plaintiff. That's the question. It's not a question of, expanding the duty, the question is whether Dr. Petrito said, okay, I have someone who's vomiting, I've stabilized her. But then the question is I don't think I can countermand a directive to give her the gentamicin. Okay, above my pay grade, perhaps I should consult with ID and say, okay, this is what is presented here. Maybe we need to skip this and then have it referred to the PCP on Monday, et cetera. I think what was raised by the record or by the plaintiff's expert here is that opportunity to avoid increasing the dose that she'd been getting since March 19th, which ultimately led to renal failure days later. That's the precise issue.
And Your Honor, you raise a good point, and my response, which is laid out in my briefs, is as follows. The patient was stabilized. The labs themselves did not reveal an emergent situation, and she was discharged with specific instructions to follow up with her infectious disease team at New York Presbyterian and her primary care physician within 1 to 2 days. Now, it gets to another point, which is a critical point. And the question is, ultimately, what is the consequence of Dr. Petrito's failure to have placed a call? Who knows if somebody would have picked up? Who knows if she would have reached anybody at midnight? The point is, however, that her primary care physician received the lab work, and by Monday, the following Monday, less than 48 hours, reviewed the results and told her to wait. There was nothing to do. Your symptoms had improved. And here's the critical point. Fast forward 6 days later, on 3/27, the labs were repeated, and gentamicin again was administered by the infectious disease team. Now, you take a step back and you ask the question that was required of the plaintiff's experts. Okay, had she made a phone call to the infectious disease team, what would they have done? What should they have done? And the expert, forget about the plaintiff's infectious disease expert, because that affirmation was not addressed to my motion, as for Dr. Petrito. Only the emergency room expert's affirmation was addressed. And that expert admittedly speculated, well, the infectious disease team could have continued gentamicin, they could have discontinued it, they could have tapered it, they could have ran any number of tests without specifying what tests they were, let alone what those tests might have shown. The record, the clinical and lab record on 3/23 for those limited 5 hours revealed no emergency situation that should have prompted a reasonable emergency room physician to contact anyone other than stabilizing, discharging the patient, and moving on to the next emergency. But at the end of the day, the plaintiff's expert's opinion on causation was completely speculative, and the plaintiff, at oral argument, admitted that the expert could not speculate as to what tests would have revealed what result and how the damage, if any, could have been mitigated. So at the end of the day, whether or not the court agrees that there was an improper expansion of the duty of care for emergency room physicians, whether or not there's any criticism of the standard of care for Dr. Petrito, at the end of the day, we are stuck with the record that we have, and the expert admittedly speculated on causation.
Thank you.
That cannot be made up at a trial. Thank you, Your Honor.
May it please the court, Ellen Fisher on behalf of the Kingston Hospital. I'd like to address the question a little bit more that was just discussed. Whether a duty was triggered to directly call an infectious disease consult, we're dealing with a situation where the patient was under the active care of other physicians. The primary care physician is the one who sent first he treated, or rather his covering physician, treated the nausea in question with Zofran, then sent the patient to the emergency department, and labs were done. Our papers included an argument that the risk of stopping that medication at that point was so strong that it outweighed the risk of ototoxicity. I don't believe that the plaintiff's opposition has addressed that. And when they say it was a departure to give that medication, in parentheses, without talking to somebody first, the next step to that has to be, okay, well, what would have happened if they spoke to that physician? One third of the way through the course of treatment for a deadly blood infection, Would they have said, okay, hold off, no, don't give the pill? We don't really know because nobody said that in any of these opposition papers. They said maybe they would, maybe they wouldn't, they needed to think about it, they should have considered it. Secondly, when Dr. Petrito looked at the discharge papers from New York Presbyterian, the person that said on there that was supposed to be handling labs, handling the gentamicin, was Dr. von Reusner. That's exactly who Dr. Petrito sent the labs to. The patient was discharged on the morning of the 24th, and Dr. von Reusner had these papers by no later than the morning of the 25th. He was the point person. He said that himself. And an emergency room doctor can't be following up and, doing labs, ongoing. At paragraph 26 of the expert's affidavit states that even if they had gotten through to the actual infectious disease doctors, maybe they would have ordered that she have daily testing of her renal function outside the hospital. Well, that's what Dr. Petrito tried to have done. And as an emergency department physician, her duty ended there. And the attempt to impute what may or may not have been done correctly subsequently to her does expand the duty of an emergency room doctor.
Well, I hear what you're saying, but what I'm trying to think about is we have a plaintiff who is manifesting clear symptoms that are the side effects of gentamicin. No one really is debating that.
Mm-hmm.
We have routine labs being done to assess. That's fair. We have the doctor treating the nausea and vomiting. That's fair too. The question becomes, and you raised this, should the doctor have consulted with ID to determine whether she should have been administered gentamicin in light of the fact that she was experiencing the very side effects? Now, you raised the issue of the risk-benefit analysis because she had Klebsiella, which is an extremely potentially deadly bacteria, and I understand that. But that's what ID is trained to do. And I don't mean call New York Presbyterian. Was there the possibility that Dr. Petrito could call an ID person who was on duty over the weekend to come in as a consult? Is that beyond the pale? I believe that was alluded to because I believe Dr. Issa, in discussing this with the PCP, pointed out, you are free as the point person to have your own ID people weigh in. You don't necessarily have to bother us, although we're available. So there was this possibility of Kingston being able to supply an ID doctor. Is that beyond the pale here? Do you think the duty could have triggered just a simple consult from someone upstairs somewhere in this hospital?
I don't believe that that was addressed by the plaintiff's opposition, but it goes back to the same question of what would have been the determination at that time, 1/3 of the way through that treatment.
Let me ask you a follow-up question to that, which goes to the same question. Is there any evidence in the record whatsoever that if she had consulted another doctor, that other doctor would have told her to get off the medication that night, do not continue it? Is there any evidence to support that next step of the analysis?
Well, I can tell you there's evidence that that wouldn't have happened in the form of Dr. von Reusner not doing that the next morning.
Didn't take her off it the next.
Right, and then he allowed the doses to continue for 7.
Did he actually acknowledge receiving that call?
He did, and
He missed a whole lot of calls.
well, he, in my reply brief, I have a quote from his deposition, a kind of lengthy one, of all the things he was aware of. He was aware the patient was on gentamicin. He was aware even of the fact that the records recommended that the patient follow up with the primary within 1 to 2 days for repeat labs. He acknowledged that. So what I'm suggesting is that Dr. Petrito gave the information that was necessary, and it was in the hands of the right person approximately 24 to 28 hours later. And that nobody has said that a patient who has been taking gentamicin for 5 days for this type of infection should have stopped that medication.
And he wasn't sued, is that correct?
He was not.
Okay.
Thank you.
Thank you.
May it please the court, your honors, Sharon Elmele for the respondents, Andrea Gill and William Gill. What we have here is a situation where, where appellant's counsel, in their need to zealously advocate for their clients, have apparently played a little bit fast and loose with the facts. And I can understand how that can happen. But there have been some misrepresentations here today about what appears in the actual record on appeal. I will start with Dr. Petrito's counsel, who you just heard from, who said very clearly that there was no evidence in the record that Ms. Gill was presenting in an emergency situation on the evening of March 23rd, 2013.
Let me go straight to the heart of what we've been asking about and ask you the question. Is there any evidence whatsoever that if she had consulted with any of the other doctors, that they would have told her to take the plaintiff off the medicine? Is there any evidence to support that argument? And without that, how can you possibly have causation?
Nobody asked any of the defendants at their depositions, the New York Presbyterian Hospital defendants, what is your opinion as to what should have been done on March 23rd? However,
even from your own plaintiff, your own expert, isn't it your burden to make that showing that if they had consulted someone, they would have been told, take her off it? Isn't that part of what you have to show to make your case against the emergency room?
Our experts said that the experts would have weighed in on the situation as it stood that night and would have decided if taking her off the medication completely would have been the right step or adjusting the dose downward.
Or would have done it? Wouldn't there have to be a direct statement that, yes, if we had been consulted, we would have taken her off the medication, and therefore you missed that chance to take her off it that night?
With all due respect, Your Honor, I don't believe that the only option available to the proper physicians would have been taking her completely off of the medication. They could have tapered down the dose, all the while monitoring her urine output.
The emergency room was just doing emergency treatment. She was being discharged, her symptoms had abated. The duty you're talking about is an ongoing duty. It sounds like that maybe a treating physician would do, but not an emergency room.
Well, we're not
tapering off, et cetera.
There was no attempt by our expert to expand the duty of an emergency room physician because our expert made it clear that she was in an emergency situation with regard to her kidney function that evening, and that situation, if unaddressed in as little as 24 hours, could have deteriorated to more severe renal injury. So she was already in AKI, which is acute kidney injury, and with continued vomiting and with continued administration of gentamicin and Tigasil, the level of gentamicin in her body would have been increasing even within the next 24 hours to the point where it was so elevated that it would be considered poisonous and become ototoxic. And that was the entire gist of the plaintiff's affirmation, is that Dr. Petrito was under an obligation to recognize the emergent nature of this situation, not just to treat the dehydration by putting more fluids in this patient, but to recognize that something was causing that dehydration, and that the moment this woman left the emergency room, that something was going to continue to cause further dehydration.
Can I ask you, what document was it? I mean, the doctor in the ER had certain labs. What did the lab say that would, at that point, because the lab is static, what did the lab say that would have indicated that the levels would have continued to go up?
Well, the labs showed, according to our expert, that Ms. Gill's serum creatinine was elevated and out of range. And when you compare it to her baseline serum creatinine level from when she was still at New York Presbyterian Hospital, it was more than double that initial baseline level. That in and of itself indicated a problem with renal function. In addition, her GFR, which is glomerular filtration rate, on March 23rd at Kingston Hospital was significantly decreased from the level which a lady of her age should have had, indicating decreased filtration of the kidneys at that point already. Might I add, as to Dr. Petrito, that she lulled this patient and her husband into a sense of security by suggesting, in writing only, because she certainly didn't stress it verbally, by suggesting that another day or two could go by before another doctor had to look at this situation. And she did not specify to Mr. or Mrs. Gill that there was potentially a problem with the kidneys and that the kidneys were the focus. Mrs. Gill herself submitted an affidavit indicating that if anyone had given her any inkling that her kidney function was at risk, she would have made phone calls herself. She
Yes,
would
but
have asked
that,
questions.
I'm sorry, I didn't mean to interrupt. That affidavit is contrary to her deposition where she claims she was too sick to recall anything.
Well, you know, I know that that's the interpretation by appellant's counsel. I don't believe that the affidavit is actually contradictory. You know, you cannot remember a lot and perceive a situation as being a blur and yet be expected to remember a clear warning that your kidneys are failing. And if she would not have remembered or understood your kidneys are failing, her husband certainly would have understood it had it been spelled out to him by a medical professional at Kingston Hospital. And that person, the only person available to do that, was Dr. Petrito. If I may now go to the New York Presbyterian Hospital defendants and their alleged negligence.
Counsel, your time is up, so, you know, I gave you the time you asked for.
Okay.
I'll give you 30 seconds to tell us what you would like to on that.
Thank you. A complete failure in a very short phone call before the antibiotic regimen was changed over to gentamicin and Tigosil, a complete failure to advise Dr. von Reusner of what was going on with this patient, and a failure to send even one page of documentary evidence advising him, you are now taking over the care and management of this patient.
Thank you.
Thank you.
Well, I'll just quickly say that Dr. von Reusner's notes on the Monday morning specifically acknowledges that the patient was on gentamicin, so he obviously knew that the patient was on gentamicin. Thank you, Your Honor.
Thank you.
And just very, very quickly, Your Honors. I did not stand up here and represent to this court that there was no emergency on 323. What I said was that the emergency was what she presented with, the clinical symptoms, the lab results themselves. No expert proffered by the plaintiff stated to a reasonable degree of medical certainty that those labs indicated an emergent situation. And in fact,
Counsel, opposing counsel said that the lab, I asked what did the lab show, and she said that it showed that the kidney function level at the creatinine level, whatever it was, I can't recall, was twice what it was when she was at Columbia at the hospital. Is that accurate?
I don't know that that's accurate, and I don't have the numbers off the top of my head, Your Honor, but her own emergency expert.
Well, let me ask you this.
Comment.
If those levels were more than double, would that have been a red flag that Dr. Dr.
Petrito
Petrito should have recognized? I have Dr. V, Dr. P. Would that be, if it was twice the amount, more than double, would that be something that she should have recognized?
No, because that's counsel's interpretation, and in fact, her own expert said that those lab results are equally consistent with A or B. A mere possibility of something happening is not an emergency situation. Dr. Petrito exercised her judgment in an emergent setting, stabilized the patient, as she was expected to do, and discharged her with specific instructions. Now, Your Honor hit the nail on the head, if I may just finish.
I want to make sure I understood what you just said. So, someone goes to an emergency room, a lab result shows, it could be one of two things. One of those two things could end up in renal failure. The other is just, I'm nauseous and I need to keep on getting treatment for the nausea. And those two, did I hear you right?
No.
Because it seems to me if the labs could be really dire on the one hand and simple on the other, you don't just discharge them and not raise the red flag that, you know, if you start feeling anything in this direction, get back here immediately because your kidneys could shut down.
Well, respectfully, Your Honor, the lab results on 323 were not dire. They were not dire. We're talking about one of three possible indicators.
That as she continues to take this medication, that the numbers, if indeed her situation was headed south, the longer she continues to ingest this medication will only increase those numbers and the direction southward, no?
We don't know that.
We don't?
We don't.
So if you take this really, really strong medication that can cause kidney damage, and the body is not responding well, such that it's doing more harm than good, it seems logical that the longer you take it, the worse off you're going to be. And so it seems to me in that situation, you would want this person tested every day.
Which she was instructed to do, and she was instructed
Well, no, they said 1 to 2 days. That doesn't have the same.
Well, I would like to get to that, Your Honor. And in fact, you know, the issue of gentamicin is a strong drug pitted against an admittedly life-threatening blood-borne infection. The idea that the plaintiff was lulled into a false sense of security is complete nonsense. When at her testimony, as Your Honor pointed out, I could not recall anything. I was so sick, I could not recall anything. That is different than saying, I was in a fog, but I would have remembered something this important. Completely opposites, and this court, I don't have the case in front of me, but this court, every court in New York State has recognized feigned issues of fact in an affidavit to avoid the consequence of testimony. And in this case, she cannot hide behind that affidavit when she clearly previously testified that she did not recall whether or not she was given verbal instructions. She was. The testimony was that she was. She cannot change it now with an affidavit. Now, on the issue, and I apologize, I recognize that my time is up.
The husband also, though, doesn't remember it either, and he wasn't under the cloud of sickness or medication, correct?
Not that I'm aware of, Your Honor, but at the end of the day, what I wanted to finally conclude with is this court in 2017 in Schenkman versus Savransky, 154 AD 3rd, 592, hit the nail on the head, consistent with every other court, every other appellate division in this state, which is plaintiff, in order to raise an issue of fact on summary judgment in a medical malpractice case, has to proffer an expert opinion that addresses to a reasonable degree of medical certain causation. In this case, that expert did not. There's no ambiguity, there's no dispute. There was an admission by counsel at oral argument, which the court did not pick up on, and the expert in the affirmation.
Don't assume what we picked up on or didn't pick up on, counsel.
Well, it was addressed on the record, Your Honor, and it wasn't addressed in the decision. But in any event, the point remains that the expert did not proffer proper causation opinion testimony, and that is fatal to plaintiff's ability to raise a prima facie, to raise a question of fact to defeat summary judgment.
Thank you.
Thank you, Your Honor.
Just to return to the issue of the difference in the two testimony in the affidavit. At her deposition, the patient testified that she was so out of it that she doesn't remember anything and it's a blur. In her affidavit, she says she was lucid, clear as a bell, and she remembers everything perfectly. Those are two opposite things. She was also given instructions in writing to go back to her doctor within 1 to 2 days. She contacted that doctor within 1 day. And again, just to re-emphasize that the risk of discontinuing that medication was even more severe possibly than ototoxicity. And I don't think and believe that the expert in the opposition adequately addressed that issue, and also hedged very significantly that all that would be done with it, we would consider reducing. We would consider, maybe they would consider letting her continue to test on an outpatient basis. It's not said, stop that gentamicin, reduce it. They just didn't say it. And I think that in a situation like this, that was necessary. Thank you.
Thank you. Thank you all.
How long was court supposed to be today? It was 1:40.
140, right?